Um, and the International Intellectual Property Law panel is hosted by the Rutgers International Law Society and co-sponsored by the Rutgers IP Law Society. I'm Deanna Davis, and I'm co-president of the International Law Society. On behalf of both societies, I would like to thank everyone for joining us, and especially thank our wonderful panelists for participating in today's discussion. I will say first a few words about today's topics and then introduce our first panelist. Intellectual property law in of itself is a broad umbrella term, which can often be intimidating initially for students as it encompasses various practice areas. There are two main branches of IP law, that of patents and of so-called soft IP, which consists of everything else IP related, such as copyright, trademark, trade secrets, and right of publicity or privacy. Professor Trimble has graciously offered to provide an introduction to the field of international intellectual property. When discussing IP law in an international context, it is important to note that the protection and enforcement of IP rights varies by jurisdiction and are territorial. This is clearly seen in the areas of IP law, such as copyright, trademark, and right of publicity. Even within the US, there are separate federal and state protections for these rights, let alone internationally. Professor LaFrance and Mr. Skrine have kindly offered to highlight the right of publicity today, which is a right that varies by state within the US, but interestingly has no direct equivalent in the UK. There are alternatives to it, which we look forward to hearing Mr. Skrine discuss. And we would be remiss in discussing IP law in an international context, not to mention the matter of choice of law. And we're thankful that Professor McNichol joins us today to provide some insight into this necessary subject. As I have previously mentioned, I began recording, and I will post today's panel on the International Law Society's YouTube channel. And I'll post a link in the chat as our discussion continues. So without further ado, I will now introduce our first panelist, Professor Marketa Trimble. Professor Trimble specializes in international intellectual property law and publishes extensively on issues at the intersection of conflict of laws, private international law, IP law, particularly patent law and copyright, and on cyber law. She has authored numerous works on these subjects and is the co-author of a leading international intellectual property law casebook. Her areas of interest have led to the investigation of alternative dispute resolution mechanisms employed to resolve intellectual property disputes, such as disputes regarding internet domain names and IP infringements at trade shows. She is a member of several professional and academic organizations. She is an elected member of the American Law Institute and of the International Academy of Comparative Law, and she's a member of the Scientific Advisory Board of the Max Planck Institute for Innovation and Competition. Professor Trimble joined the University of Nevada, Las Vegas after receiving her second doctoral degree from Stanford Law School. Professor Trimble, we're very happy for you to join us today.
Thank you. Thank you very much for the kind introduction, Deanna. It's a pleasure to be here. Let me share my screen. My assignment is to give you an overview of international intellectual property as an introduction to my other co-panelists. So it's a pleasure to be here today. I am delighted that the International Society and the IP Law Society decided to team up for this kind of event because international intellectual property is sometimes not really the focus of a main interest of students interested in international law or in intellectual property law. And that's a big mistake because it is a very important intersection of various areas of law and something that's really actually quite a hot topic. You might wonder, if you are interested in international law or in intellectual property law, whether this is really a very niche area of law, a very niche thing to worry about, or whether this is something that might even have some practical importance for what you might be doing. One thing that I do in my classes is early on, I try to convince my students that this is actually not only some kind of big picture thing that they might not even encounter in real practice. I am trying to show my students that this kind of issues, the issues that arise in the general umbrella, under the general umbrella of international intellectual property law, is something that they will encounter in their daily practice, and probably very soon. So let me talk about first IP in general. As Diana perfectly described, there are many areas of intellectual property law. Most of them are on the slide, but not by far all of them. Copyright and so-called neighboring rights, although we just call everything copyright in the United States, is something that most of us encounter every day. Even if we don't know about it, all of us are very likely copyright owners. Patents are, of course, a different story. Very few of us will end up being owners of a patent, but many of us might encounter people who do innovations, who make inventions, and we will probably use products and processes that involve patented technologies. If you own and use a cell phone, you actually have patents right there in that machine that you use every day. Your computer is very likely to involve multiple, if not hundreds, of patents. Trademarks are, of course, in our daily lives, something that we see all the time surrounding us, including on our computers. Trade secrets, very much related to patents and inventions and things that companies do that is very valuable. And it's valuable particularly because they can keep it secret and have some kind of advantage on the market and in the industry because they created and own these trade secrets. Unfair competition per se is not really an intellectual property right, but certainly we do have regulation of unfair competition within the larger IP law umbrella. Design protection, again, if you think of your cell phone, of your computer, of cars, of chairs, there are many examples of designs that are protected under intellectual property rights. Geographical indications of origin are perhaps something we don't know in the US as much because we are not exactly the champions of this area of law. It's the Europeans and particularly the French who are completely obsessed about protecting their appellations of origin and names of different cheese and all that. But we are not completely unfamiliar with this concept, right? Think of Vidalia onions and think of Idaho potatoes and Napa Valley wines. Certainly, we do have the kinds of indications of origin that other countries protect under geographical indications. We have different ways to protect them, but we care about them as well. Database protection, again, in the US, we don't have a specific IP or quasi-IP right to protect databases, but we use other areas of law to achieve the same goal. You are probably familiar with internet domain names, which in fact are treated as IP rights. And there are also intellectual property rights to new plants and new plant varieties. In addition to all these and some other types of intellectual property rights, we also have rights and policy matters that are being discussed at the World Intellectual Property Organization now. That is the main world organization that deals with IP rights. And those other types of issues involve folklore, genetic resources, and traditional knowledge. And there have been a lot of discussions about whether some kind of protection, maybe not IP rights, but maybe something similar, could be extended to genetic resources, to traditional knowledge and folklore to provide some type of protection to them. As Diana pointed out, there are various perspectives on intellectual property rights and intellectual property law that all fall under the larger umbrella of international intellectual property law. We could describe it as a combination of three perspectives: public international law, private international law, and comparative law. Let me talk about three practical examples to illustrate how these perspectives work in the area of intellectual property law. Let's start with public international law. When you think of public international law, often people think of protection of human rights, the law of the war. Well, yes, those are all public international law topics and issues, but people often forget that public international law involves many let's say perhaps more pedestrian areas of law, where public international law has actually achieved great goals, and where public international law keeps developing quite quickly. And intellectual property law is one of these areas of law. Public international law, of course, is built out of treaties, but treaties are not the only source of public international law. We have other types of sources of public international law. But in intellectual property law, public international law are primarily treaties. So let's look at one example of why public international law might be actually important. Think of the COVID-19 vaccine. These vaccines will all probably be protected by a patent one day. And if not the vaccine, certainly some kind of treatments, methods of treatments, maybe some new pharmaceuticals, drugs that people will be able to use to hopefully one day treat COVID-19 successfully. The question is, if there is patent protection on all these drugs and maybe vaccines, is it the right route to take? Shouldn't we make sure that these types of inventions are not monopolized by their patent owners? Maybe we want to make sure that all countries have access to these vaccines, to these medicines, and maybe patents will be sort of in the way because the patent owner has monopoly in the IP law sense, and without a license or permission, you cannot manufacture, distribute, or use these vaccines or medicines. Well, in international IP, we actually have a provision that allows countries to introduce a so-called compulsory license. Now, when countries negotiated the treaties, they were very careful about the scope of this particular provision, because of course it's important to provide patents to incentivize innovation, and we don't want to stifle innovation by making too many exceptions to patents that would de facto result in the patent having no really rights attached to it whatsoever. So countries created this provision about compulsory licensing. And as you can see, for instance, Canada was one of the countries that very early in the pandemic adopted a law, a statute that actually makes it possible for the Canadian government, if it decides to do so, to issue a compulsory license, a license that forces the patent owner to make the invention available to other manufacturers, to other distributors, and so forth. Canada, again, was only one of the countries that acted pretty quickly. Now, this is not to say that the country will, in the end, issue a compulsory license. The law only makes it possible for the government to do so. There are many considerations, tactical considerations, strategic considerations to take when a government decides whether or not to adopt a compulsory license. If you are interested in some of these difficult decisions, you can read about the Indian government issuing some compulsory licenses in recent past. So this is an example of how public international law, a treaty, affects daily lives of citizens, of inhabitants of a country, and how a country has to reflect international law when it implements its policies. Let's move to private international law, or what we call conflict of laws. This is probably the area of IP, international IP law, that you as practitioners encounter very early. My students usually email me the summer after they graduate that they have already encountered a case that raises some conflict of law issue. Here is an example, a very recent example of a conflict of law issue in intellectual property law. So we know that these days it's sometimes very hard to make money off of motion pictures, and merchandising is a very important component of the business these days. Well, Lucasfilm was not particularly happy to find out that its own business of merchandising, selling all these helmets and outfits that people love to wear at Comic-Con and other different festivals and so forth, this business got a competitor, Mr. Ainsworth in England. And he was a very successful competitor because he is the original designer of some of these designs for Star Wars. So he was able to use his original molds to create these designs, and he started selling them online on his own website. So you could go online and purchase the same helmet from Lucasfilm's website or from Mr. Ainsworth's website. As you can imagine, Lucasfilm was very upset about this and decided to sue Mr. Ainsworth. They sued him in the United States, in California. Mr. Ainsworth never showed up, and the court in California therefore issued a default judgment. This was reported in the news as a significant victory for Lucasfilm, but there was that next step. So what? You have a judgment from California. Who cares? And Lucasfilm learned this the hard way because its lawyers brought the decision, the judgment, to the UK to have it recognized and enforced against Mr. Ainsworth. But they were not successful. They were not successful because the court in the UK said, you know what, under our law, under UK law, under English law, you all and the court in California had no personal jurisdiction over Mr. Ainsworth. It might have had jurisdiction under your own law, under US law, but in order to recognize a judgment in the UK, the original judgment, in our case, the California judgment or US judgment, had to comply with certain jurisdictional minimum, and that was not complied with in this case. So that was a perfect example of how conflict of laws issues are extremely important to know about if you practice IP law. And they are important to know about not only at the end when you already have the judgment in your hand, but at the beginning before you even file a lawsuit. So let's talk about briefly comparative IP law, which is what we do in my international IP class. Most importantly, we do so because, of course, by learning about countries' differences in IP law, you actually learn about the need for international IP law. You learn about where international IP law also leaves space for countries to adopt different approaches. So in this particular case, which is a little actually funny, SAS, a software company, had a ClickWrap license in which it prohibited its licensees to engage in any kind of reverse engineering. World Programming downloaded the software and did exactly what the contract said it couldn't do. It engaged in reverse engineering. SAS brought a case against World Programming in the UK, alleging violation of the license. When asked which law should apply to the licensing issue, SAS decided that English law could probably apply because its lawyers concluded it must be the same as US law. Unfortunately, they didn't conduct a real comparative law analysis because they would have found out that English law had to implement a European Union directive, which invalidates any contractual provisions that prevent reverse engineering of computer programs. So this was a huge problem because, of course, SAS lost in England based on English law. By the way, the case had a follow-up because SAS decided to bring the same case in North Carolina. World Programming argued res judicata. The court in North Carolina said that it would not recognize the English judgment, and more mess ensued. So this is just an example again of how comparative law is very important in intellectual property law issues. So this was in terms of brief introduction. I hope this is helpful and look forward to my colleague co-panelists' presentations. Thank you.
Thank you very much, Professor Trimble. That was a wonderful introduction and very in-depth look, even though quite brief, but well researched and well presented, and gives us students a good introduction to this area. So we'll now turn to Professor LaFrance, who's also from University William S. Boyd School of Law, University of Nevada Law School, with a discussion of the right of publicity in the US and globally. So Professor LaFrance joined the faculty of the William S. Boyd School of Law in 1999. She received her JD from the Duke University School of Law, and she practiced for 3 years in Washington, D.C. in Freed, Frank Harris, Shriver, and Jacobson. In 1990, Professor LaFrance joined the faculty at the Florida State University College of Law, where she taught IP, taxation, and entertainment law, and also served on the faculty of the Florida State University School of Motion Pictures, Television, and Recording Arts. Professor LaFrance has authored 3 books on IP, trademark, and copyright law. And her teaching and research interests include domestic international IP law, as well as taxation of intellectual property. Professor LaFrance, thank you very much for joining us today.
Thank you very much, Tiana. And thank you to the International Law Society for hosting this wonderful event. And thank you to my wonderful colleague, Professor Trimble, for providing, as usual, an outstanding introduction to the subject of international intellectual property. So I am going to attempt to do some screen sharing. Let's see if we can get this working. All right, is that showing up for you?
Yes.
Okay, let's see if I can go into slideshow mode. See if it'll still work. Okay, so far so good. My topic is the right of publicity. And I'm going to give a bit of an introduction to the US approach and a little bit of comparative law before throwing it to the rest of the panel to deal with the UK approach and some conflicts questions. So I want to start by introducing the...
I think it seems frozen.
Is it frozen?
Yeah, it's changing slides.
So you just have the first slide.
We have the outline, the list of the slides, so it didn't go into slideshow.
Oh, it did not go into slideshow. Okay, let's go back.
Oh, now it seems to be working.
All right, we'll just stay there and you can try not to be distracted by the upcoming slides, the preview of upcoming attractions on the left-hand side of your screen. Okay, so can you see my new slide?
Yes, thank you.
Okay, all right, thanks for letting me know, appreciate it. Okay. So first, let me introduce the general concept of the right of publicity for those of you who might not have been exposed to it in the past. My description of the general concept applies, I think, fairly accurately to both the United States and to other countries that recognize the right of publicity. So the general concept is that the right of publicity is the right of an individual to prevent the unauthorized use of his or her identity by another for the latter's advantage. And usually this is a reference to commercial advantage, although there is some case law in the US saying that it does not have to necessarily be commercial in nature. Now, the right of publicity can be viewed as either a personal privacy right or as an intangible property right, depending on the jurisdiction. And some jurisdictions actually take both perspectives. Under a personal privacy theory, the concept of the injury is based on the idea that the person whose identity was used suffers from some embarrassment or injury to feelings, some sort of emotional harm, because this is an invasion of their right to have their personal privacy respected. Under the property theory, the right to a remedy is based on the notion that this is an unauthorized appropriation of the commercial value of the person's identity. And this concept is certainly easy to understand in the case of celebrities who at least partly make their living off of controlling and commodifying their identity. But it has also been applied to non-celebrities. So the property theory can apply in theory to any person who is injured by the unauthorized use of their identity. But it is most easy to understand in the case of celebrities because it's very easy to assign a commercial value to their identity. And some jurisdictions combine both of these theories. Some proceed under one or the other. In contrast to protection under trademark law or unfair competition laws, there is no likelihood of confusion required in order for a plaintiff to make out a right of publicity claim. This is in contrast to false endorsement claims under unfair competition laws, where the celebrity's identity is being used to promote some goods or services and could lead to the false impression that the celebrity endorses those goods or services. So that sort of deception or confusion is not necessary where the plaintiff proceeds under a right of publicity theory. And at least in the United States, it's not unusual to see plaintiffs proceeding under both theories. If they can show some likelihood of confusion, they might prevail under trademark or unfair competition theory. If they are not able to prove a likelihood of confusion, then they might still prevail under their right of publicity theory. And sometimes they prevail under both. So let me talk a little bit about the United States approach to the right of publicity. And that's a bit of a misnomer because there is no uniform federal right of publicity. So there really is no United States approach. Instead, we have a state-by-state approach. Most states do recognize some version of the general concept of the right of publicity. Sometimes a state might recognize this through its common law as an outgrowth of privacy law or general tort law. In the states that recognize the right of publicity as a matter of common law, the scope of the right can be quite unclear because it is developed on a case-by-case basis, just like any other area of common law. Among the states that do recognize the right of publicity, which is the majority of states, it is most often recognized through a statute. And in the case of a statutory right of publicity, the contours of the right tend to be more specific because the legislature has to hammer out various questions about the scope of the right. However, it is also possible for a state to recognize both a statutory right of publicity and a common law right. And this is true in California, which decided in a case involving Bette Midler that even though her claim did not meet the requirements for the statutory right of publicity, California had never disposed of its common law right, and she was therefore able to proceed under the common law right of publicity. Clearly, there is wide variation in the scope of state protection of the right of publicity. This can give rise to conflicts of law questions, even in domestic litigation, where a celebrity who is a resident of one state brings a right of publicity cause of action under the laws of a different state. In general, the right of publicity under US state laws can be licensed or even assigned outright. And an example of that would be the professional sports leagues in the United States, where a professional athlete has to assign or exclusively license certain aspects of their right of publicity to their professional sports league, but they are allowed to retain other aspects of their right of publicity. The strong protection for the right of publicity in the US can give rise to some interesting conflicts with other legal doctrines. It can conflict with copyright law. For example, in the use of photographs of a person, film clips depicting an actor, for example, performing a particular role, sound recordings that feature a particular, usually a vocalist. If these are used without the permission of the subject or the performer, the question can arise whether the performer has a claim or whether the only person who has a claim is the person who owns the copyright in the particular tangible fixation. And this can give rise to copyright preemption questions. And there's quite a lot of case law addressing whether and when the right of publicity is preempted by federal copyright law. Also, the US right of publicity can conflict with the protections afforded by the First Amendment. And this can arise in many situations where a particular person's identity is part of an expression that receives some First Amendment protection. For example, news reporting, works of art, such as paintings, works of criticism or commentary, tabloid journalism and the activities of paparazzi, who love to stalk and photograph celebrities without their consent, and the tabloids that publish those photos, docudramas about someone's life story or their involvement in historical or newsworthy events, works of fiction that are inspired by real people or events, but depart slightly from the actual facts, tribute bands, celebrity impersonators, and video games, which have been the subject of quite a lot of right of publicity litigation in the last decade or so. In dealing with these conflicts, courts have to employ various types of balancing tests or what has become known as the transformative use test. All right, so those are some general points about the US approach to the right of publicity. I've talked about state variations, and here's some examples of how states differ in their approach to the right of publicity. They can differ as to what is protected, what aspect of identity is protected. Most common and pretty universal is protection for the name and likeness of the person. However, variations include protection for the person's voice, an imitation of their voice, their nickname, catchphrases associated with them if they are performers, for example, distinctive clothing or accessories that are associated with them. There's a case involving the distinctive appearance of a race car that was associated with a particular driver. There's a case involving imitation of Santana's guitar playing style. And there's cases involving a particular song that is strongly associated with a performer, cases involving Bette Midler and Nancy Sinatra, for example. There's also variations in who is protected by the right. There's at least one state statute that expressly protects only state residents. In other states, courts have used conflicts analysis to deny protection to non-resident celebrities. Another major difference involves post-mortem rights. Does the right of publicity survive the death of the individual? If it does, some states say it does and some disagree. If it does survive, under what circumstances does it survive? For example, is there a requirement that the celebrity have commercially exploited their right of publicity during their lifetime? If there's a postmortem right, how long does it last? Is it perpetual? Is it for a limited term of years? Does it lapse if if the heirs do not enforce it for a certain period of time? Also, if it is descendable, does the state require the heirs to register their claims in order to put the public on notice that the right will be enforced? And another difference is in statutory exceptions. States that have a statutory right of publicity sometimes write in specific exceptions for certain types of activities. For example, in Nevada, we have an exception for live celebrity impersonations, because that is a significant part of the entertainment business in Las Vegas and to some extent Reno. Some states have exceptions for sports reporting and sports commentary, where the athlete will be depicted in images or videos in connection with reporting and commentary on the sport. Okay, so clearly there's a lot of differences even within the United States. So my last slide is a bit of an introduction to the right of publicity outside the United States, where there is a lot of variation. In civil law countries, the right of publicity is fairly widely recognized, including the civil law countries in continental Europe and in the more developed nations of Asia. The right is less widely recognized in common law jurisdictions, with one significant exception, and that is India, which pretty clearly recognizes the right of publicity. If you're researching the right of publicity outside the US, you will find that different terminology is often used. It might be called the image right, the personality right, or the portrait right. So if you're doing a search, you might want to plug in these different terms. Some, but not all of these countries recognize postmortem protection. In countries that have strong protections for free expression, the courts are forced to figure out how to balance an individual's right of publicity against the speaker's right of free expression, much as we see in the United States. Now, even in countries that don't recognize the right of publicity, there is some limited and analogous coverage if they have neighboring rights laws, or if they belong to an international neighboring rights convention. Neighboring rights laws and conventions will protect a performer's right to prevent unauthorized fixation of their live performance. So that is one aspect of the right of publicity. And sometimes they also have a right to collect equitable remuneration from the uses of these fixations. But apart from neighboring rights conventions, there really are no treaties, and there's really no harmonization of the right of publicity per se. Therefore, there is great potential for conflicts of law. In the EU, an issue that remains unresolved is how to deal with broadcasts or digital transmissions from one EU country to others within the EU. Where does one need to obtain permission to exercise somebody's right of publicity? In the country of origin, or in every country where the broadcast or the transmission reaches? And if there's an infringement, which country's law will determine what the scope of the right of publicity is and whether there are any applicable exceptions? However, I've not seen a lot of case law that sees this as a serious problem. Outside of the United States, most countries that recognize the right of publicity seem to be willing to apply their domestic protection even to foreign personalities. So that's quite different from the US, where courts have often refused to protect people from the United Kingdom on the grounds that the United Kingdom does not have a right of publicity. A great example of this willingness of countries to provide domestic protection to foreign personalities was a case that arose in Japan, where the plaintiff was a UK actor named Mark Lester. And if you've ever seen the movie musical Oliver Twist, Mark Lester was the boy who played Oliver Twist. Well, many years later, as an adult, he brought a right of publicity claim in Japan, and the Japanese court applied Japanese right of publicity law to protect his interests without citing any issues involving conflict of laws. So that's my little introduction to the right of publicity in the US and around the world. And I will now turn it over to Deanna and the rest of the panel. Thank you very much.
Thank you, Priscilla Frantz. That was very in-depth and a great introduction to the right of publicity. We will now turn to Mr. Skrine, who will discuss the alternatives to the right of publicity in the United Kingdom. Mr. Skrine is a senior partner in Reed Smith's Entertainment and Media Industry Group. He leads the firm's responsible business program, Europe, Middle East, and Asia. His practice is mainly in litigation, but also advises about conflict and potential conflict situations, including crisis scenarios. Mr. Skrine specializes in IP and media law and in public and regulatory law, both domestic and international. He has considerable experience in multi-jurisdictional disputes and is well used to the role of lead lawyer for clients in jurisdictions other than England. Mr. Skrine has been consulted over the formulation of statutory tribunal codes and made submissions concerning parliamentary drafting and law reform in the UK and abroad. Mr. Skrine has been an expert witness on the English law of trade secrets in the US federal proceedings and on the English law of passing off in state proceedings in California. He holds a Master of Arts degree from the University of Oxford and Southern California and is a visiting professor in the School of Law at Queen Mary University of London. Thank you very much for joining us, Mr. Skrine. So you're muted. There.
Well, I started by getting it wrong and saying good evening. It's not evening for most of you or any of you, but anyway, I'm going to show a slight affiliation here by putting on a cap, which I hope it doesn't cause any offense to people in Nevada. But anyway, there we are, there's a Rutgers cap. So yeah, I'm talking about alternatives to the right of publicity in the UK. And the reason I'm talking about alternatives is, as already been foreshadowed, we don't have such a right in this country. Just to deal with that reference to the UK, there are 4 nations in the UK and 3 different legal systems. So I'm going to talk about English law. I think the position is very similar in Northern Ireland and Scots law. And when I say English law, that means the law of England and Wales. So that's 2 of the nations where the law has been combined for a longer period. In this neck of the woods, we have some islands off the mainland. One of them is Guernsey, which I know that Professor McNichol knows a lot about. And that actually does have a registration system for image and personality rights, but that's very unusual. So I'll look at what our alternatives are. And we obviously have to do this because there's a natural inclination of people to want to protect their image, and either because they want to exploit it themselves and not have other people do it, or because they don't want anybody using their image. And so we often get asked, and I'm very often asked by colleagues in the States that are somewhat disbelieving of the fact that we don't have a right of publicity. This is particularly difficult to explain to Californians, I find, but there we are. The first branch of law that we have available is the law of confidence. So this is really a law about trade secrets or secrets, confidential information. It is not a law about privacy. It dates back, or at least the key early case on this was a case from 1849, which was a case in which Prince Albert sued somebody called Strange, William Strange, over some drawings. And then the big case about it was the 2005 case of Douglas and Michael Douglas and Catherine Zeta-Jones challenged the use of the unauthorized use of wedding photos. It was a complex case, and it went very high, and one branch of it went to the House of Lords, which was our Supreme Court at that time. But that is about, as I say, that's where you want what you want to protect, or what you are able to use in order to protect yourself, is information. If we then move on to privacy, or privacy for some people, that is something that is completely different, but is now available to us as a remedy, and it has been for about 25 years, something like that. And that comes from the European Convention on Human Rights, which Article 10 of that gives you a right to, gives families a right to privacy. It's actually something that the convention was set up after the war as a way of trying to guarantee that you wouldn't have the secret police knocking on your door at night, but it's become broadened into a wider use of privacy. And that stemmed from a case that involved Princess Caroline of Hanover, who's Grace Kelly's daughter or granddaughter, I can't remember which. I think daughter, and pictures of her at a supermarket with a child, I think. And the question was, should she have a right of publicity, or sorry, of privacy, not a right of publicity, but in a sense, if you can protect using privacy, if you can put something around you that protects your privacy, then that means that other people can't publicize you. The question there was, well, how come you say that's private? You went out to the supermarket, you didn't have a paper bag over your head. Why is that private? It's easier to see why it might be private with a child who's been taken somewhere. So there was a case about Paul Weller, who was photographed in Santa Monica, and then and his child got protection. That's very easy. But why should you have a right of protection if you choose to go out and so that anybody can see you? Anyway, that went to the relevant European court, and the reason for that, which I can explain offline to anybody who really wants to know, is that Germany, Princess Caroline lives in Germany, didn't intervene, and that was because the Chancellor of Germany was at that time having a spat with the newspapers about whether he dyed his hair. And so the question was, is that privacy or is that libel or what is it? Anyway, he didn't want to intervene because he wanted to preserve the right of privacy for anybody, especially himself. The big case here then on privacy was Naomi Campbell's case against the Mirror, which is from 2004. And that was a case where she was photographed waiting outside a drug rehabilitation center. And there was a public interest defense put up, but it failed in that case. Another much more recent case in which the public interest has been asserted but unsuccessfully is a judgment that came out on the 11th day of this month from Mr. Justice Warby, who's actually now Lord Justice Warby, having been promoted, not for this result, I don't think. That's Meghan Markle's case against the Mail on Sunday. And that was about publication of a letter from her to her father. and the court said that she had a right, that was something that she was able to defend because she has a right of privacy. What that really means is still being worked out because of the fluidity that arises from the fact that this comes from Article 8, and it's not in Article 8. It doesn't tell you why you've got such a right. But it seems to be about a zone of privacy that you have around you. It was defined by a court, leading court, as follows: the respect for individual autonomy that lies at the heart of Article 8 means that the starting point is a person has a right to exercise close control over particular information about her private life, to decide whether to disclose anything about a given aspect of that life, and if so, what to disclose, when, and to whom. So confidence and privacy are completely different things. For a long time, the English courts got confused and thought they were much the same thing. They're not, but they do, obviously, as you can see, go hand in hand, and there have been cases where both have been involved. There's a 2007 case in which the Prince of Wales sued Associated Newspapers, same people that Meghan sued. A special aspect of privacy is data protection. There was a data protection claim in the Campbell case, in the Naomi Campbell case that I was talking about, so that's a much more technical kind of data protection law is very technical. At the moment, we now have GDPR, which you may or may not have heard about, but that's the European law. It's different from America. In fact, the two jurisdictions don't trust each other. But it's very technical, and I'm not going to go into that in the time I've got available. I can tell you, though, that in the Campbell case, they had different barristers, advocates, talking about the different aspects of it. And when the privacy one had finished, he said he was going to sit down, and he told the House of Lords, and I'm now going to hand you over to the anaesthetist, and that was the lawyer who had to advance the data protection claim. An interesting point, and then a very important point that has arisen out of GDPR, came out of the Google Spain case in 2014, and that is what was called the right to be forgotten, which is now called the right to erasure. Sorry, erasure, not Eurasia, erasure. So it is very important that people now do have the right to get Google, Bing, and so on delist in certain circumstances. Next thing I'm going to mention is copyright. Written materials such as diaries, or in Meghan Markle's case, letters, are subject to copyright protection, and that is sometimes it's possible to use that. And certainly in my experience, when there are cases about publicity and one's trying to protect, in effect, to protect the right of publicity, one's often looking for photos and wondering who owns it. Is it the photographer? Is it the people who commissioned it? The next area I'm going to talk about is passing off, and that's where a lot of attention is focused on that. In 2002, there was a case about called Irvin, which said that people have goodwill in their own image. Passing off is about the protection. It is where you've built up a goodwill of any kind, can you protect that by saying that other people can't misrepresent things, goods, or anything, by suggesting that they've got something to do with you? The big case on this was a passing off case called Fenty in 2015, which was a case that went to the Court of Appeal. This case concerned a photograph on a t-shirt, which I'm going to hold up in case anybody can see it. Oops, you probably can see it. A bit of it there. This is my rather crude form of document sharing. And it's a picture of Rihanna, and as you can see, she's looking straight at you. That's because she was there, she was at a publicity shoot. A photographer was there and took a picture of her, or pictures of her, and then published them, and that was perfectly lawful. And so the picture on here, on the t-shirt, was not, there was no copyright case to be available to be used there, because there's nothing wrong with the use of the photo or with the taking of the photo. The question then was how can one stop a shop, Topshop, selling t-shirts that have got this image of Rihanna? It's a case I know quite well because it was my case. And obviously we were accused by our opponents of, in effect, making a claim for a publicity right. And they told the court, well, this is just a claim for a publicity right. But that's not good law. You can't do that. We, of course, said that this wasn't publicity right at all. It was just very traditional passing off right claim. Well, of course, it wasn't very traditional, but both the judge at first instance and the Court of Appeal ruled that it was a passing off because it was her goodwill. She built up goodwill, including in fashion items, and she was entitled to protect it and not have people act as if they were anything to do with her. There were particular reasons in this case why one could say that they did make it look as if they were something to do, as if she'd authorized it. And finally, there's registered trademarks. As we're talking about comparative law, I should say that trademarks, that's two words in English. I know it's one word in American, but it's two words in English. So that's a little tip for you as you go forward in the law. In the Rihanna case, if you went into the shop and bought one of these t-shirts, there was a swing tab, a label on it that had Rihanna on it in capital letters. That is a registered trademark. So one of the things we complained about was we said it was passing off, but we also said there was a registered trademark claim. It won't surprise you that the registered trademark claim was settled immediately because they were, they just took the labels off, they had to. There was nothing controversial about that. But so registered trademarks often are a valuable way to protect publicity. David Beckham has registered a lot of trademarks. Yeah, so that's our little assortment of rights that we use. And I will now pass on to Professor McNichol, I think.
Thank you very much, Mr. Scrine. That was a great explanation of how in English law mainly, and I suppose maybe in Scots law and Northern Irish law as well, it really employs the creative thinking that lawyers need to take advantage of in order to somehow defend some alternatives to right of publicity. We'll go on to now Professor McNichol. Professor McNichol has been a member of the Rutgers faculty since 1999. He brings to the classroom his experience as a leading member of the intellectual property bar for 30 years, having graduated Villanova Law School. Professor McNichol specializes in copyright law, IP international business transactions, patent law, and trademark law. He has represented clients in patent, trademark, trade secret, and copyright cases in trial courts nationwide and in the courts of appeals. He has lectured throughout Europe, South America, Asia, and the US on the acquisition and enforcement of IP rights. And Professor McNichol has lectured on IP law throughout the globe. He's also a member of the bars of New York, Washington, and the US Patent and Trademark Office, and the Canadian Intellectual Property Office. Professor McNichol, thank you very much for joining us.
All right, well, thank you, Deanna. I too will be doing a little bit of a screen share. What I'll be talking about today will be about how we choose between the bodies of law that are available to us. I think the earlier speakers have made it clear that there are a lot of bodies of law out there. And the question now becomes, how do you pick one? So let me bring up my PowerPoint, so it's there. And see if I can, there we go. So if that's available on everybody's screen, let's dive into it.
Yes, it is.
Notice we're not talking about, conflict of law, choice of law, two slightly different concepts, but that's what we're talking about. How do we make the choice between various bodies of law? As the other speakers have done very well, they pointed out the many different sources of right of publicity law. For example, US versus English law, but of course there isn't any right of publicity at all in English law, but other jurisdictions do have their own version of what we would call in the United States right of publicity law. On the national level in the United States, for example, you have federal versus state law. Now, state law is typically the font of right of publicity law, but as was pointed out earlier, that it can be limited by the federal Constitution, most frequently the First Amendment to the Constitution, which imposes free speech prohibitions, or it makes it impossible to limit a person's free speech. And Olivia de Havilland was actually the subject of a recent docudrama about her difficult relationship with her sister, and brought an action in California courts. And that was successfully defended by the producers of the docudrama on a First Amendment basis. Back and forth between California and New York, we'll talk about that a little bit more. But we do know that that's plenty right there to create interesting problems in terms of choosing which body of law to follow. As has also been pointed out by the earlier speakers, that there is no international treaty or convention that would serve to harmonize the substantive right of publicity law. So there's nothing like the Berne Convention or TRIPS or something like that that applies to right of publicity. So we have every imaginable opportunity to go off in different directions in different jurisdictions, both as to the reasoning behind having a right of publicity law and what that right of publicity will extend to. So this actually works out to be something that you would sort of expect. And these differences in both the rationale and the scope of the law can be outcome determinative. And that makes choosing the body of law potentially outcome determinative. The textbook example, literally the textbook example of how that can be outcome determinative is the case involving the heirs of Marilyn Monroe. As time goes on, it becomes more and more important to point out to the audience that in the late 50s and early 60s, Marilyn Monroe was as big as they got. And even today, she remains a figure of some cult-like status. Every few years, there's another biographical film. A lot of memorabilia tends to get sold attached to her name or things like that. A consequential person in the entertainment industry, to be sure. She finished her life in California, but before that, she was a New York resident, married to Arthur Miller, and she studied there at the Actors Studio, trying to hone her craft. But at the time of her death, even though she had a house in California, she claimed to be domiciled in New York, largely for tax purposes. And when her will was probated, her executors continued with that, again, largely for tax purposes. That happened in 1962, when she died and her will was probated. A long time after that, and it's been many years, the cult-like following that she has only grown. And seeing that a lot of people were making money attaching her image, to things, producing statuettes of the famous subway grate scene where the subway goes by and blows her dress up. That was in the movie The 7-Year Itch. So a lot of money was being made from that, and her heirs were getting nothing. Now, Marilyn Monroe's will said nothing about her right of publicity. She made specific bequests to specific people, but then had what's called a residuary clause that says, and everything else I've got, I give to certain named person. So they became what's known as the residuary heirs. And if there was a right of publicity that she could will to somebody, it proceeded to her residuary heirs, who then brought this case, the Green versus Marilyn Monroe LLC case. The choice of law issue was one between California and New York. Under California law, and I'm not purporting to describe all of California right of publicity law, but the important part was that under California right of law, the right of publicity survives to your death and it can be passed to your heirs. Under New York law, it does not. So the question that we had to answer was which law applies. This was going to be an outcome determinative choice of law issue. Well, the answer is pretty clear. The popular and most common, almost universal choice of law principle is domicile at time of death. Now, domicile, so well, she had a house in California and she died in California in her own home. Why wasn't she a California domicile? Well, domicile means your permanent and principal home to which you intend to return, even if you're currently residing elsewhere. So by claiming to be a New York domiciliary, she was saying, I'm just here in California for a little while. So military folks, for example, if they get sent by the Army or the Navy someplace out, in the United States or outside the United States, they retain the domicile of their home when they entered the military, unless they then evidence some kind of desire to return to some other place. So she had taken the position for a long, long time, mostly for tax purposes, but that's the way it works, that she was a New York domiciliary. And since the domicile at time of death rule was the near universal choice of law principle that operates in these situations, she was going to have to live, or her residuary heirs were going to have to live with the New York choice of law. And so the court, the Ninth Circuit, sitting in California, said that because Monroe died domiciled in New York, and New York doesn't recognize a posthumous right of publicity, the residuary heirs were out of luck. Okay, one could say, so what? Because this doesn't seem like a terribly unjust result. There was no widow or orphan left starving. There was no fraud involved. There was no sharp dealing. There were just residuary heirs who decades later decided that there was possibly a pot of gold that they wanted to mine. And so people made note of this, but nobody was outraged, except possibly the residuary heirs, but even they may have simply been disappointed. What I'd like to do is suggest a few hypotheticals that suggest that the domicile at death rule is probably not the most appropriate, okay? And in any event can produce unintended or mischievous results. And I'll pause at this moment to note that Professor LaFrance has contributed to the scholarship on this point quite extensively, and that has to be acknowledged. So here's my choice of law hypothetical. And yes, this person you see here is Bruce Springsteen. And we choose Bruce Springsteen because Rutgers is the state University of New Jersey, and the boss lives here in New Jersey. Okay, in my hypothetical, the boss, a lifelong New Jersey resident and taxpayer, enters into an agreement transferring his right of publicity completely and for all time to Asbury Park Incorporated. He gets paid a boatload of money, and having bought this right from him, Asbury Park invests in exploiting the right that it has just paid a boatload of money to acquire. Okay, these kind of transactions do happen. But then the boss makes a move. He moves from New Jersey to New York. Why would he do that? Well, perhaps to take advantage of less rigorous enforcement of the DUI laws in upstate New York. Those of you who follow these things closely will be happy to hear that it was announced this morning that Bruce Springsteen did a plea bargain on his DUI arrest, so he's not going to jail. But in my hypothetical, he moves to New York for whatever reason and really moves to New York. He registers to vote there, sells his New Jersey home, pays New York, not New Jersey taxes. You can see that I'm setting this up. He's a New York domiciliary at this point. And he does that a couple of years after he sold his right of publicity to Asbury Park. A couple of years after that, it's inevitable, he dies. After his death in 2016, his children, as well as several unrelated companies, begin to sell merchandise emblazoned with his likeness. Okay, that is to say, exploiting his posthumous right of publicity. The question then becomes, under the domicile at time of death rule, which would dictate New York law, he has no exclusive rights after his death, and Asbury Park has no posthumous right to exploit by having acquired it from the boss. So does that really work? Is it really fair to allow his heirs to take advantage of that? And my hypothetical is heirs were part of that, even though they may have derived considerable benefit from the $75 million that their father got. The unrelated companies are in a slightly different position, but is it really fair, okay, to treat the Asbury Park people the way they get treated? And would it be fair to treat some people differently than others? In other words, say to the boss's heirs, you can't exploit his right of publicity, but the unrelated companies can, or the other way around, I should say. So that is a difficult sort of situation that needs to be worked out. It's probably not a just result, okay? And it sort of cries out for the application of a different choice of law rule. How might you do that? We'll talk about. Is this hypothetical too hypothetical? I don't think so. Because if you're following these sort of things, Stevie Wonder just moved out of California to Ghana. Right? He announced his intention to permanently reside in Ghana, okay? I don't know whether any of my panelists are up on Ghanan right of publicity law, but suddenly Stevie Wonder's lawyers are going to have to become experts in that if he assumes a domicile in Ghana. Either that or they're going to have to do damage control, and he's going to have to maintain some kind of residence within the state of California, where he currently lives, so that he can say that, well, I'm going to be coming back and I love the United States and I'm just in Ghana because I like the weather and whatever. So they have to do damage control on that move. So the hypothetical is not terribly hypothetical. People move around, okay? And the death at domicile rule is not likely, okay, to be universally helpful, okay? So what do we do in this point? Well, I think there's two main routes to solving this problem of outcome determinative choice of law rules. One would be to reduce the differences in law so that you could pick different jurisdictions as the source of governing law and not get different results. The other would be to have better choice of law rules. The first category would be what we might call harmonization. And harmonization is actually a very active and popular line of reasoning in a lot of intellectual property law. Certainly is popular in patents, it's popular in copyrights, popular in trademarks. So there's certainly precedent for that. That would operate at several levels. Within the United States, domestically, we often have uniform laws that are proposed to the states for adoption by a private organization called the Commissioners on Uniform Laws. So a uniform law on the right of publicity would reduce the number of cases where a choice of law rule was outcome determinative and would allow greater consistency in the exploitation of the right of publicity, people's persona. Another possibility would be the adoption of a federal law, invoking a Commerce Clause power that would not completely displace all state law, but it would, again, reduce the inconsistency. And there would be, of course, no major choice of law problem as long as you're always applying that federal law. An international convention would be, in my view, very desirable, but probably not possible to achieve anytime within my lifetime, because a lot of countries, won't name any of them, don't even acknowledge the existence of a right of publicity, or if they do, it's fundamentally different. So until there's a consensus first within the United States and other jurisdictions such as the EU on what they think the right of publicity ought to be, you can't get them all together and say, well, now let's talk about how our different views can be reconciled or harmonized. So that's way off in the distant future, but it is something that I think is where we need to go if we're going to resolve this. So if cheese makers in France can get appellations brought under a convention, I think movie stars in Hollywood and music makers in New Jersey can probably exercise a certain amount of influence to get that done within their jurisdictions. So that's the short version, I hope, of the topic. Meant not so much to exhaust the topic or to suggest that there's a set of bright line rules that are consistent and just and always easily applied, but simply to suggest that this is an area of law that is ripe for development. And all of you who are interested in it, students, should find this to be not only interesting, but an area where you have an opportunity to either contribute to the scholarship in the area or to work with your clients who may need to have their rights of publicity protected. So with that, I will turn the baton back over to Deanna.
Thank you very much, Professor McNichol. That was a wonderful discussion of choice of law and really relevant as well. So I would like to thank all the panelists again for their wonderful presentations and enlightening discussion. And we will now turn to Q&A and see if our audience has any questions. If not, I have a question myself, but okay. I'll let the audience have a go at it. If not, I guess I can start off with, since this is a society sort of a panel, I have a question for the students for IP study and later on. So would you, any of the panelists, have any advice in starting off a career in practicing in IP, patent or other areas, copyright, publicity, entertainment law, and later on, what is some advice that you would offer for people who are already practicing in this area? What are some things that you should think about, or some advice in that regards?
I would just say very briefly to actually point to something that you, Diana, said at the beginning about the division of IP law into soft and the harder IP law. I don't actually use this distinction because I always tell my students, no, it's, yes, for patents, you might have to learn more about science, technology, but it's not like if you practice copyright or trademark law, you don't need to know anything about your client's business or technology, in fact, right? There's a lot of technology involved in copyright, trademark, and other areas of IP law. So I would just say, don't expect IP law to be entertaining necessarily. It might be, and I love the area of law because it is often entertaining, but it's also a very complex area of law, very challenging area of law, and you will have to learn about your client's business no matter which area of IP law you will do.
I think you're exactly right about that. And I think if IP law is right for you, it should be something that encourages you to be curious and responds to that. It's difficult to learn about your client's business if you find it dreadfully boring. If it's like dragging fingernails across a blackboard, you're never going to be able to force yourself through that. So, and people always tell students and young people, follow your interest, and follow your passion. And what if you don't know what your passion is? Well, expose yourself to stuff. And if you find that it's stimulating your curiosity, then you're in the right field, and run with that. And if you're curious about something, then you're a step away from finding that much talked about passion that everyone tells you to pursue. And if you keep that up for the rest of your professional life, you're great.
Yeah, I agree with that, and I'd just say, so in our system, you don't need to have done a law degree to be a lawyer. We have different ways of doing it. So I just became a lawyer and just went around in the training system that we have, which is a kind of apprenticeship thing where you spend 2 years moving around the office, learning about shipping law and all sorts of things in our firm. So I kind of stumbled on intellectual property and media law. And you may well find that you do that too. So, but yeah, follow your nose, really. Follow what intrigues you.
That also involves, I guess, pursuing some things that, upon reflection and a few months of exposure to it, serve the function only of demonstrating to you that was not something that you weren't interested in. That's a valuable experience too, to confirm that suspicion that it was a dreadful bore and you need to look at something else. So being open to experiences that are not guaranteed to be the passion of your life is kind of important. It's just a job. You're not getting married.
And I'll add that if you're a law student and you're interested in a possible career in IP, I would strongly recommend getting exposure to some exposure to all of the different IP areas, because when clients come into your office, they think they have one kind of IP issue, but as you interview them, you may discover that, in fact, they have a very different kind of IP issue, or they have several different types of IP. So the client may have mischaracterized their needs to you. So make sure you know a little bit about all areas of IP. If you want to do trademarks, then you really need to study design patents as well, because those are very valuable for the protection of trade dress. I would also say you should study administrative law and federal courts, because those can be very, very crucial in IP. And if you're planning on entertainment law, I would try to pick up some labor law and tax as well.
Well, that was certainly the driving force behind Marilyn Monroe's problem. I think somebody, I think it was, Professor Trimble mentioned organizations with student memberships. That's a good vehicle. Another thing that I often suggest is continuing legal education. Now, for those of you who haven't even graduated from law school, it may seem a bit premature to mention continuing legal education requirements. But if you're interested in a certain area of law, wills and trusts, and you go to a wills and trusts CLE, crash it, volunteer to help. I remember back in the before days when we had in-person events, volunteer to help organize and do things like that, just for the sake of being there. And you will meet the people you're working with, talking about the issues that you will deal with. And so you can spend a few hours with that, and you can decide, this is the greatest thing going. I'm all excited for it. And you'll have met with and talked with people in the field. It's great to have those connections. On the other hand, you may find the trusts and estates makes your flesh crawl, and you'll never want to do that again. And that's a valuable thing to get out of the investment of a few hours of your time. So my suggestion is crash a CLE. You'd be surprised how receptive organizers of continuing legal education courses are to a student who will voluntarily make their time and energy available to help pull the event off. And then you're there, interacting with people who practice in the area that you might be interested in, and you can determine whether that area of law is of interest to you and whether the people who happen to practice that area of law are of interest to you. I'm the patent attorney here. I can tell you that patent attorneys are not everyone's cup of tea. You know, you might just find that, you know, that's just not for you. So yeah, that's a good thing that I would suggest.
Thank you very much. Does anyone else out of our audience have a question regarding the presentations today, the relevant topics, or additional questions regarding careers? If not, I suppose, do we have another question? We have a question from the audience. How is Shaki? How does one go about gaining experience in this area? But I think we've already sort of discussed crushing in on CLEs, sort of volunteering. Professor Campbell mentions organizations with student memberships, and she's listed some WIPO online tours, which is actually very interesting. I didn't know about that. I'll go check that out. And we have another question from Madeline Coles.
Yeah, I could address that since she was directed to me. I think that harmonizing or making more uniform the right of publicity could take any of the several methods that I mentioned. The whole idea of the Commissioners of Uniform Laws was to make law uniform from state to state within the United States. So that it's voluntary, no state is required to adopt those laws, but typically they do. And so the Uniform Commercial Code, with which you are all familiar, is a good example of that, how that harmonized the law of contract for sales of goods. So, you know, I think the other way is to deal with it on an international level. There have been for centuries, actually, going back, I guess, to I don't know, Michael, do you remember when the Paris Convention, or Mary, when that was adopted well back into the 1800s?
Yeah, it's before my time, Bill.
Before mine as well. Yeah, so there's an ample precedent for international conventions that commit countries to conform their national laws to certain basic principles. The Berne Convention, the United States did not adhere to until 1990. That was around for a long time, but that required the United States to harmonize its copyright law with the convention. So it's you know, that would be a route, but I don't see that being practical for many years.
I think a problem that one could come across, I don't know how it would be in the States, but here, if you were to try to get a right of publicity recognized, for instance, I could imagine quite a lot of difficulty getting that through Parliament. You know, so I think it would be this is quite an ambitious project you've got there, Bill.
Well, if it wasn't ambitious, why would
why bother?
Why bother? Right. If it was easy, everybody could do it, right?
And we have students who are quite interested in gaining experience, so maybe we can have some volunteers to take up on this offer, on this ambitious project, hopefully from this panel. So I've again posted the link to our YouTube channel. So this lecture will be up there, and you can also look at the other panels that we've had in the past. I'll once again say thank you to our wonderful esteemed panelists for discussing much needed topics in international intellectual property law. And we're very glad our audience has joined us today. And thank you so much again. We hope you have a wonderful rest of your day or evening for Mr. Skrine.
Thank you, Diane.
Thank you.
Stay well.
Bye. Bye-bye.
Thank you.